Hello, and welcome to JD Advising's California Bar Exam Essay Guide. The goal of this guide is to help you find an effective and efficient approach to the California Bar Exam essays right from the very beginning. This guide will help you feel confident on test day so that you can conquer the essay portion of the California Bar Exam. If you have any questions about this or other resources we offer for the California Bar Exam, please don't hesitate to contact us. Some of our other resources include a California Bar Exam prep course, private tutoring, essay feedback, and one-sheets. If you reach out to us, we'd be happy to speak with you about the resources that can best help you prepare for the California Bar Exam. We hope you enjoy this guide and good luck on the exam. The next subject that we're going to discuss is remedies. This is an interesting subject because California labels it as a separate subject, but a lot of what is covered under the topic of remedies stems from contract law or tort law. For this reason, we often see remedies crossed over with other subjects. First, let's discuss how remedies is tested. The California bar examiners almost never ask examinees to apply California law to a remedies question, so you should expect to apply general law here. As I just mentioned, this tends to be tested as a crossover question, most often with torts or contracts. Sometimes it is clearly crossed over with another subject, but the examiners still just label it remedies. It's helpful to think about the underlying claim in a remedies question, so if the claim is breach of contract or negligence, in addition to the remedies that the party could potentially seek, because there are potentially substantive defenses that could be raised regarding that claim that could negate whatever remedies the plaintiff is seeking. For example, in October 2020, remedies was combined with contracts, but they actually just labeled it as a remedies question. And the call of the question asked what defenses the defendant could raise. One of those defenses was the statute of frauds. So understanding the substantive claims can help you identify and discuss all of the necessary issues to maximize your points. The call of the question for remedies generally asks, what remedy or remedies can the party or parties seek? You should start by identifying any legal remedies before discussing equitable remedies. But you should identify all of the potential remedies that might be available, and don't just settle on one specific remedy that you think the party should go after. Next, be aware of the highly tested issues in remedies. We see monetary damages come up again and again, so be sure that you know the difference between compensatory damages, punitive damages, and restitutionary damages in tort cases. Compensatory damages seek to put the plaintiff in the position they would have been in had the tort not occurred. Punitive damages seek to punish the defendant and deter future conduct by both the defendant and others. Punitive damages are not actually awarded in negligence cases, but they can be awarded in intentional tort cases. Restitutionary damages seek to avoid unjust enrichment by allowing the plaintiff to recover the value of the benefit conferred on the defendant. So, for example, if someone driving negligently hits my car, I could recover compensatory damages to cover the amount of damage done to my car. And if, let's say, they intentionally hit my car, I could also recover punitive damages meant to punish that other driver for their wrongful conduct. Another highly tested issue is temporary restraining orders, or TROs, and preliminary injunctions. When this is an issue, you should almost always discuss both. TROs are emergency orders issued before a preliminary injunction meant to maintain the status quo until a hearing for a preliminary injunction can be held. The moving party has to show that they will suffer an irreparable injury before the preliminary injunction can be obtained, and a likelihood that they will prevail on the merits of the underlying claim. A preliminary injunction is granted before a full trial on the merits takes place. A TRO can only be in place for a very short period of time, but a preliminary injunction can last a little longer, so a court might grant a TRO first and then have a hearing and decide at the hearing whether they should extend that into a preliminary injunction. There are 4 factors the court will consider in deciding whether to grant a preliminary injunction. The mnemonic to help you remember these factors is HELP, H-E-L-P. The first requirement is harm, which is the danger that the party seeking the injunction will suffer an irreparable injury if the injunction is not granted. Second, the courts will evaluate the risk if the injunction is not granted. Third, they will look at the likelihood that the party seeking the injunction will prevail on the merits. And finally, the court will consider the public interest. So for a preliminary injunction, you need harm, evaluate the risk, likelihood of prevailing, and public interest. Make sure you fully explain what each of those requirements means within your rule statement in order to get full credit. I'll give you an example of TROs and preliminary injunctions. Let's say that I have some land, but a developer thinks that it's actually his property. There's a 100-year-old farmhouse on the property, and the developer is going to bulldoze the house and build some condos. I sue for quiet title, but the developer is at the property with the bulldozer right now, about to tear that farmhouse down. So I can't wait for the entire quiet title suit to conclude, because by that time, the farmhouse will be gone. So I could go to the court and ask for a TRO or a preliminary injunction to prevent the developer from being able to bulldoze the house until we can resolve that quiet enjoyment issue. In remedies questions that involve breach of contract scenarios, we often see legal remedies such as compensatory damages tested. In contracts, the measure of compensatory damages is expectation damages. This is the loss of the value of the breaching party's performance, plus incidentals, plus consequentials, minus any expenses saved as a result of the breach. You don't generally have to do any math on the exam. Just be able to discuss what these different types of damages include. So for example, let's say a wedding planner orders 500 white roses for a wedding. The day of the wedding, the florist sends 500 pink roses. The planner pays a rush fee to have a different florist deliver the white roses, and this other florist actually charges an extra $2 per rose. The wedding planner can sue the first florist. She could recover compensatory damages of $2 per rose. That's the additional price she had to pay. She could also recover the rush fee as an incidental damage because this is a cost that she incurred to avoid the loss from the breach. Finally, if the bride sued the wedding planner for, let's say, emotional distress, the wedding planner might also be able to recover consequential damages from the florist for this expense if the wedding planner can show that these damages were foreseeable at the time that the wedding planner entered into the contract with the florist. In addition to legal remedies, you should also consider potential equitable remedies in breach of contract cases, such as specific performance. A party would seek specific performance if they don't want money damages, but instead they want to receive what they contracted for. It's easier for courts to just assign money damages to breach of contracts cases, so they don't really like specific performance, and this remedy is usually only available in cases that involve land or unique goods. Also, anytime you discuss equitable remedies, be sure to discuss equitable defenses. The equitable defenses that are frequently tested include unclean hands and laches. Unclean hands is a defense when the plaintiff is acting in bad faith with respect to the same transaction. Basically, the defendant is saying, I might have done something wrong, but so did you. Laches is an equitable version of a statute of limitations. This defense is available if the plaintiff unreasonably delays in pursuing a claim, and that delay results in prejudice to the defendant. The next tip for remedies is to be aware of how to approach highly tested remedies topics. For instance, when the examiners test specific performance, they are looking for a very specific structure and certain things within your analysis. In order to obtain specific performance, a plaintiff must show a valid contract, that all conditions have been met and the plaintiff has performed or is ready to perform, that a legal remedy is inadequate, that it is feasible for the court to order specific performance, and that the defendant does not have any defenses. You should have a mini IRAC for each of these 5 requirements and thoroughly analyze any facts and potential arguments that support or refute each of those elements. Another topic to be aware of is constructive trusts. Whenever constructive trusts are tested, equitable liens should almost always also be mentioned, even if a constructive trust is a more appropriate remedy than an equitable lien. Finally, certain damages principles are tested repeatedly and should be mentioned in your answer. For instance, you should state that damages must be foreseeable and not speculative. You must discuss whether the sought damages are foreseeable. Also, state that the plaintiff must mitigate damages and be sure to contemplate whether the plaintiff has done everything possible to mitigate their damages or if there are any other steps that the plaintiff might be able to take to mitigate their damages. Finally, as I previously mentioned, you should state that punitive damages are not available in negligence or breach of contract cases. Generally, you should still mention punitive damages if you see a negligence or a breach of contract fact pattern, but then simply state that punitive damages would not be awarded in this type of case. The 4th tip for remedies is to practice. This will help you see the patterns that often come up in the structure of this type of essay, as well as many of these highly tested issues. We recommend that you start with the remedies questions from February 2021, July 2017, February 2017, and February 2016.